Robert Wilkins was found guilty of murdering Tony Fondinant and sentenced to 52 years. In 2004, he lured Tony to the bayou, who was casually wearing shorts and no shoes, when Mr. Watkins stabbed him and slit his throat. Less than halfway through his sentence, he is up for parole. Let's take a look.
My name is Robert Wilkins.
What's your DOC number?
My DOC number is 581134. Date of birth, September the 9th, 1976.
Thank you, Mr. Wilkins. Let me, before we get started, I'd like to acknowledge the folks who have joined us by Zoom. We have here in support your brother, Raymond Wilkins. He'll be speaking on your behalf at the appropriate time. In opposition, joining us by Zoom from the Calcasieu District Attorney's Office, we have Natalie Connor, Harry Fontenot, and Jacob Johnson, the Assistant District Attorney. Ms. Fontenot and Mr. Johnson will be speaking at the appropriate time. Also joining us is Harry Fontenot, Sherry Willis and Julia Fontenot. And at the appropriate time, we'll call on them for their remarks. So, Mr. Wilkins, let me just put some identifying information into the record, sir. You're classified as a first felony offender. You're currently serving a 62-year sentence. You were sentenced in Calcasieu Parish, May the 1914. Possession of marijuana, you received a 12-year sentence. Possession of cocaine, a 12-year sentence. And manslaughter, a 40-year sentence. So your total sentence is 52 years. You have a parole eligibility date, which was September 22nd, 2024, and your good time release date is September 28th, 2037. Is that information correct, sir?
That is correct, ma'am.
Okay. So, Mr. Wilkins, before we get started with our interview, we'd like for you to tell us what led you to prison, why are you in jail, and why do you think we should vote favorably for you today for parole?
Well, what led me to prison started long before I actually got here. It was a lifelong addiction to alcohol and drugs, namely cocaine. I've made a lot of bad decisions on my way to get here, which ultimately took an innocent man's life. It's something I still struggle with, and a lot of people, I'm sure, wouldn't believe it. I do bear that guilt and that responsibility on me every day, and it will be with me for the rest of my life. There's a lot of things I've had to look at personally, a lot of things I had to admit to myself, a lot of things that I had to work on dealing with my issues. A continuous effort to acknowledge my faults, my shortcomings. I understand what I've done, and I take full responsibility for them. I understand the precious life that I robbed from individuals because of my decisions and because of my selfishness. There's nothing I could ever say or do to replace that precious piece that I took from somebody. But I'm here to let them know that I am sorry. I'm sorry for what I've done. I did not have to do it, and everyone is suffering because of my actions. Again, that guilt and that responsibility will lie on me for the rest of my life.
All right. So why do you think we ought to vote favorably for you today?
If we talk about it in terms of rehabilitation and never being in this situation again, that's one thing. But like I said, there's issues that I've had to deal with. There's stuff that I've had to admit, stuff I've had to work on, and stuff I've continuously strived to work on. It's about going forward and never returning backwards. And I'd like to think that I've shown a valiant effort in that department. I'll always be an alcoholic and drug addict. That'll never go away. That is a struggle that I've had since I was 10 years old. It's something I will struggle with for the rest of my life. But I do have right over 10 years of sobriety. And that is something I could say I have never had in my life.
Okay, thank you. Warden Wardlaw, is there anything you can tell us about Mr. Wilkins?
Yes, ma'am, I sure can. I'll speak about what Robert's done since he's been here. You know, currently he's a Mint 2 trustee. He works in maintenance as a plumber, does an exceptional job with that, works real hard, and is always willing to work. And also, he serves as our inmate counsel substitute for our disciplinary procedures here. So he floats between the two of them, and he's very active with the law library and stuff, and helps out a whole lot right there. He since he's been here, he's taken a lot of good classes that he was, definitely needs to have. He's thinking for a change, cage your age. He's completed the victim impact class. Looking at it, I did see that, he still needs to get that living in balance phase 2. And we can definitely see about getting him into those, finish up that class as well. He's done pre-release. And I do want to point out, since he's been incarcerated here, he has no disciplinary history at all. So that's really impressive as well. Speaking, like I said again, what he's done here, he's definitely applied himself and done everything he possibly can while he's here. We had a good interview. I was glad that he brought up about his substance abuse problem, and realizing that he's always going to be an addict. So I would definitely recommend that he continue that if he was granted parole as well. And he does seem to have a good support system and a good plan as far as whenever he does eventually ever get released. So that's good to hear and see as well.
Yes, sir. Thank you for your input. We appreciate it.
Yes.
Now we'd like to hear from the opposition. And Mr. Johnson, I'll let you decide who would like to speak first, and we'll just hear from them in the order that you choose.
Yes, ma'am. If I could, I would like to defer to the victim's family. They are in the conference room at the DA's office first. You'll see the name N. Connor. That's for Natalie Connor. She works with my office. And if the family could speak first, I would appreciate that. And I would prefer to go after them, and they've had their chance to say their piece. So, Natalie, if we could unmute, please. And I can't see all who from the family is there. I do see Mr. Harry Fontenot, recognize him on the screen. And so, Mr. Fontenot, if you would like to speak, I would defer to you. And then if we could go kind of in order with whoever would like to present.
Okay, thank you. My name's Harry Fontenot. I was Tony's big brother. And Mr. Wilkins said he will always be an addict, an alcoholic. He'll always be a murderer. This was a death penalty case, if you read my letter, and we let it go down to second degree. Went to trial one, wasn't unanimous, because once they got to 10, they quit counting. So out of our compassion, we let him plead to a manslaughter, and we let him plead to the drugs, and he got a set time to serve. That's better than being dead or life in jail. So that was our charity to him, where he never showed us any. The contract should be in front of you. We didn't know that the DA signed, scratched out life without parole. But in the next paragraph, it says this thing intends for him to serve 52 years. If he doesn't serve 52 years, I'd like to have the contract voided, because he didn't want to adhere to it, and we want to go to trial again. You do not know what this has done to our family. Mama had a heart attack, she could tell you about. It's suffering every day. Daddy died a broken man. He's all doing good, yeah. But Tony never had the chance to finish doing good. He had his degree. He was working his way up. He did what I said in the letter. He wasn't going to start a family until he had it paid off. Wilkins is a drug dealer. He lured him to the bayou. My brother was in shorts, no shoes, nothing. lured him to the bayou, got in his truck, and slit his throat. There was blood from the crime scene all the way to the bridge. His truck was filled up with blood. He never gave my brother one thought of charity. And my mother and father gave him charity when they let him plead straight up to a manslaughter consecutive with the drugs. And in that contract, it says, with this contract, he is supposed to serve 52 years. Now we're going to be victimized again if you don't uphold that contract. If you find the contract void it. Let's go back to trial. That's all I can say. You see my letter. My sister sitting here. It ruined her life, ruined my life, and my mom and dad. And I'll let my sister go now if she wants to talk.
My name is Cheryl Willis. Tony was my little brother, and he did not deserve this. Robert Wilkins cut his throat and left him to die on the side of the road like an animal. And my family has suffered every day. The whole time we went to court for years, Wilkins sat up there with a smirk on his face while his lawyers massaged him every day. And we got to see that. This man has no remorse. He can sit up there all beefed up and say he does. He's an addict and he will be an addict. Please, for the sake of my family, I am begging you to keep him behind bars where he needs to be. Thank you very much for listening to me.
And next we have Miss Julia Fontenot. Good morning.
Yes. I'm Julia Fontenot, mother of the victim who was murdered. I'm here to oppose parole for Robert Wilkins. My son has went over a lot of the things that I was going to talk about, but I agree with everything he said, so I don't need to repeat it, but I just want to tell you, plead with you, I implore you, please do not give him parole. He does not deserve it. He assassinated my son. He assassinated his character in court without any proof of anything he was stating. He took something away from us that's so precious to us, and nobody can give it back to us. And every day, I still, when I hear a car drive up in my driveway, I look out there thinking, hoping it would be Tony. And it's been going on all these years and it won't go away. It doesn't. People say get over and have closure. The only closure I'll have is when I'm in my grave with my son. And I'm not trying to be a smart aleck or anything like that, but I think if Wilkins get paroled, it should only be on the day that my son can be paroled from his grave, then give Wilkins parole. We were misled on the thing like my son talked about, so I won't go into that, but I'm going to close this and I respectfully implore you, I beg you, I plead with you, keep that monster where he's at behind bars, because then other people will still be safe. And I thank you for listening to me. Thank you so much.
Thank you, Ms. Fontenot. We do appreciate you and your family sharing your comments with us. Thank you.
Okay, thank you so much.
Mr. Johnson?
Yes, Madam Chair and members, as you laid out earlier, Mr. Wilkins is convicted by a plea of manslaughter, possession with intent to distribute cocaine, possession with intent to distribute marijuana. I don't want anyone to be under the impression, and I know that you guys have millions of pages of documents at all times, that Mr. Wilkins is here because he's an addict. Mr. Wilkins was, in fact, while he is technically a first offender, was in fact, by his own admission, a significant drug dealer in our community, dealing many harmful substances, profiting off of poison, profiting off of other people who are addicts. I am glad to hear Mr. Wilkins say today that Tony Fontenot was an innocent person and that there was no excuse for what he did. I appreciate him saying that today. It was only about 10 years ago that Mr. Wilkins stopped putting up the facade that he was scared of Tony Fontenot and that he acted in self-defense. For a decade through the courts, he drug Mr. Fontenot through the mud over and over, repeating that he was scared, that it was a justifiable homicide. That's starting from the day he was arrested all the way through 2014 when he finally admitted his guilt. The Fontenot family did show a great deal of mercy, endorsing a plea for something less than second-degree murder. Mr. Wilkins was originally tried and convicted of second-degree murder. That matter was overturned on appeal. It was sent back for a new trial after a number of delays, a lot of wrangling. The matter was set to finally proceed to trial, and on that day, Mr. Wilkins requested and the family agreed to allow him to plead to 40 years for manslaughter, plus an additional 12 years to run consecutively for the 2 possession with intent convictions. And in that contract specifically, it's on page 5 or 6. I'll pull it up from my materials here. But it outlines that it was the design of the parties that the defendant serve the entirety of his term at hard labor with the Louisiana Department of Corrections, the entirety of his 52 years at hard labor with the Department of Corrections. I would then reference Judge Savoy in his trial transcript at his sentencing. Judge Savoy now and at that time was certainly a very experienced judge, was someone who I would say was a pretty down the middle judge, certainly not always with the state, not always with the defense. He's now a retired Court of Appeal judge, but very experienced, and he dealt with this matter, and he opined, and which I think is appropriate, that it was his opinion that Mr. Wilkins, given that he knew the facts of the case, he had overseen all of this wrangling, serve each day of those 52 years. And in fact, he made a remark that he didn't think that was quite enough, that he thought a life sentence would be most appropriate. Again, the Fontenot family provided a great deal of mercy to Mr. Wilkins for something less than life without parole. And that's because they were under the belief, understandably, that when someone signs a contract, that their own intention, the defendant's own intention, be to serve the full term of that 52 years, that ought to mean something. And we understand that there are good time laws and things like that. But here we are, a mere 10 years after the defendant accepted guilt, after 10 years of denying that he had any guilt in this matter, asking for your release. We don't believe that 20 years on a 52-year sentence is nearly appropriate. And so we would just say that we would beg of you to vote disfavorably. 20 years here for this particular killing is not significant enough. The family's been through one trial in which their loved one was just dragged through the mud quite cruelly. We're on the verge of another. They agreed to this plea with a good faith understanding of what 52 years looks like, even if there's some good time credits involved. Look, Mr. Fontenot is an accomplished lawyer. He's in fact the head of our public defender's office in Calcasieu Parish, so he understands the metrics that go into good time and all of those kinds of things. And what no one should have to expect is a 20-year sentence being the result of a 52-year sentence, when 40 of that is especially for manslaughter. I would say in this case that mercy to the guilty is in fact cruelty to the victims. I would say as a practicing prosecutor, when one is dealing with murder cases, or one is dealing with something else like a first-degree rape that has a life sentence, and you're trying to figure out if there's a reason for a plea, things like the 20-year rule can provide a moral hazard and can provide real confusion when you're talking with victims and survivors' families of what something like this looks like. In fact, I'm wrestling with that today, and so I would ask that you vote disfavorably on parole. I'm glad to hear Mr. Wilkins is doing well in prison. However, when he was out in our community, he was dealing drugs, he was causing harm, and he needlessly killed Tony Fontenot. I'm glad he's admitted that now that Mr. Fontenot was innocent. That should have not taken nearly as long as it did, but we would certainly very strongly oppose any parole release in this particular case. Thank you so much for your time.
Thank you, Mr. Johnson. Appreciate the DA's participation. All right, Mr. Wilkins, your case has been assigned to me, so I'm going to take the lead on the interview, and I do have a few questions. So we've already established through this process you've served 20 years. Is that right?
Yes, ma'am.
And how old are you, sir?
I am 48 years old.
And you do have a good time date, which I think we said in the beginning, September 28th, 2037. You mentioned that you took victim awareness or victim impact. I believe you have training in that regard. Tell us, what did you get out of that class?
That was a good class. That was an eye opener. That was actually putting yourself in someone's position. We had a facilitator who shared her personal story of loss, and it was gut wrenching. It really was. It was an eye opener, and it just kind of it was a self reflection of how someone else is affected by your personal actions. So victim's impact was another eye opener as to the hurt that I've caused because of my actions.
And we've heard many times this morning from those who spoke in opposition about your plea agreement and your contract that you made with the victim's family and the district attorney's office. How do you feel about that now?
Well, as I know and the district attorney did speak about it, there is certain laws that would prevent a flat time because I am a first offender. This issue had been brought back to the court, and the court properly denied that a flat time for this would be improper, and it was also held up by the Third Circuit Court of Appeal. There's just so much I don't want to say. I really want to be respectful. It is about hearing their voice today and acknowledging my guilt for what I've done. I believe it's fitting for the position I'm in.
All right, I won't probe any further then. So when I look at your record, I agree, I'm really impressed with your 0 disciplinary reports. How did you manage that in 20 years? We don't usually do that.
That was part of the self-reflection, the shame that I felt. It's a moment of clarity. The shame that I've actually felt for the things I've done, the people that I've hurt, not just for this reason here. A lot of people in my life that I hurt. It was because of my selfishness. So that's a big motivator. The guilt and the shame is a big motivator for change.
Okay. And I noticed, I think I saw in the record, your job is in maintenance right now, but you were attending Ashland University and you quit. Why did you quit?
Yes, ma'am. I lost someone very special to me, and I never recovered from that. And it took the wind out of my sails. It was a devastating loss to me, and that was the reason for that. It wasn't academic or any other than losing someone.
I don't see that I have any other questions. Let me just tell you, though, that you do have, in addition to the opposition we've heard this morning, you do have opposition from law enforcement, strong opposition to any early release for you this morning. So you need to be aware of that. I don't have any other questions. My colleagues have any questions? I don't see any other questions, Mr. Wilkins. So I think we should be prepared to vote. But first, I want to hear from your brother. I see Raymond, are you on the line with us?
So, can you hear you?
Yes, ma'am, I am.
Sir, tell us what you'd like us to know about your brother.
First, I would like to extend my deepest condolences to the Fontenot family for their loss and the pain that my family has caused them. But my brother he is the picture of what the system was designed for, to reform those who offend out in the real world and to teach them. He's taken the time and the effort, put in great effort to learn new behaviors and new ways of thinking and acting so he could be a productive member of society if he ever got a chance to be released. And he's the picture perfect ideal candidate of what reform is. He's done everything that it was asked of him, and he probed even further to find out what more he could do to be a better person before his release date. And he's expressed to me many a times the routes that he wanted to take when he got out, such as joining a local Narcotics Anonymous association so he can spread his story to those to hear it, so maybe he can stop someone from being in the same position that he was. My brother is not anywhere near the person today that he was when he went in. He's the man that he should have been before his issues with the drugs and alcohol. He's the man that we all knew he could be today.
All right. Well, thank you, Mr. Wilkins. We appreciate you taking the time to speak with us this morning.
Thank you.
So, Mr. Wilkins, I think that we are prepared to vote. I'll be voting first since your case was assigned to me. It's a difficult case. I think you've done very well in prison in the environment that you're in. I see you've kind of moved around a bit and you've done well. You say you've been sober for 10 years. Congratulations on that. I still am really impressed with the fact that you haven't had any write-ups in spite of the different places you've been, because I know that's very difficult to do. I agree with Warden that you need to do the living in balance too. However, you know, and I think you still need to pursue that. When I look at the totality of the record, the contract that you signed in 2014, and listening to the district attorney this morning and the victim's family, I agree that 20 years is insufficient based on the agreement you made with the victims in the state of Louisiana. So for those reasons, my vote today is going to be to deny you parole. Mr. Tillis.
I commend you on your service that you've done there in changing your life. And today's vote for me is going to be the same. I concur with Ms. Renata.
Mrs. Stapleton.
I concur with Ms. Renata. I believe that you need to adhere to the plea agreement that you made of 52 years.
Mrs. Ledoux.
I appreciate Mr. Johnson's excellent discourse on the case and how it panned out on early stages. I think you're a different person today than when you came in, but my vote is also to deny based on the length of time served.
Mr. Freeman.
And I concur for the same reason.
All right, Mr. Wilkins. Keep on the path you're going. I think you're on the right track, but today your parole's been denied, sir.
Thank you, ma'am.
What do you think of this case? Should inmates be granted the opportunity for parole so early in their sentence? Let me know what you think in the comments below. And if you like this video, please like and subscribe for a new video every week. Thank you.